Good afternoon, everyone. Welcome to the fourth session of this amazing Hawaiian History Kingdom series. For those of you who are with us for the first time, welcome. For those of you who are back again, we're so glad that you're sticking with us. It's really been a very informative and interesting series so far, and I'm sure that it will continue to be. We have just wonderful scholarly speakers. My name is Linda Rich. I chair the Justice and Witness Missional Team for the Hawaii Conference of the United Church of Christ. And we are hosting this series in collaboration with the Association of Hawaiian Evangelical Churches. So I'm going to ask Cassie Chi, who is a member of our Justice and Witness Missional Team and will be moderating the questions later. And is also a member in discernment seeking ordination in the United Church of Christ. I'm going to ask Cassie if she would lead the pule for us.
All right, everyone. E pule kako, let us pray. Mahalo ke akua for another day to gather together in learning, in asking questions. Ke akua, I pray that we may be open to listen, hear, and be transformed by the words that we hear in today's presentation. Amen.
Amen. Mahalo, Cassie. And now, once again, we will turn this over to Dr. Keanu Sai.
Well, welcome everybody to my fourth presentation and final presentation on Hawaii's history. This is what's going to get into where we left off last week, which is now what? And the strategy employed to address a very, very complex and complicated issue, especially when you bring in law and facts, right? But for those who may be here for the first time, I just want to give a brief introduction of who I am. My name is Dr. Keanu Sai. I have a Ph.D. in political science from the University of Hawaii at Manoa. I'm also a faculty member at the University of Hawaii. My specialization in political science is international relations and law. I'm not Hawaiian studies and I'm not history, but I'm political science. A lot of people think I'm Hawaiian studies. My master's and my PhD is in political science, and my research focus was on the Hawaiian Kingdom as a country. I'm the author of multiple law articles, peer review articles, publications, which can be found at my University of Hawaii website. So you can just Google Dr. Keanu Sai and go to the UH website and you see the publications there. Some of these publications are being accessible to the audience through this series. So I can identify which of my writings correspond with what I'm covering. Okay. So going back to this presentation, yeah, looking at this issue is very complex. So I'm going to jump straight right into it, and then we'll take it from there. And hopefully I would have been able to make what is complex into something that is comprehensible and a path forward that is practical. Okay, so with that, why don't we begin? Okay, so the road to recovery of ending the American occupation. Well, as we left off last week, there's a distinction between what is called the Hawaiian state, or a state, an independent state or country, and its government. So the Hawaiian Kingdom was recognized as an independent state on November 28, 1843, and as its government was a constitutional monarchy. Okay, the last head of state for the Hawaiian Kingdom was Queen Liliuokalani, the sister of King David Kalakaua, Liliuokalani's predecessor. But in international relations and law, the military overthrow of a government, in this case illegal because it was admitted to be illegal by the United States president who did the investigation, Grover Cleveland. But by overthrowing the government, that did not equate to the overthrow of the country. And that is important. And this country is called a state. And that's what's important. And it's the state that is the subject of international law, not governments. Okay. So after the overthrow of the Hawaiian government, admitted to being illegally overthrown by the United States, the state continue to exist. You don't need a government to bring back the country. The country never left. And I'm going to be covering that, reviewing it again as to why the Hawaiian Kingdom as a state continued to exist even in the absence of its government. Now, customary international law in 1893 obligated the United States as the occupier to administer the laws of the Hawaiian Kingdom and not the laws of the United States when they are in effective control of the territory. This obligation is now codified under Article 43 of the 1907 Hague Regulations and Article 64 of the 1949 Fourth Geneva Convention. Laws of war, the laws of occupation, are also called international humanitarian law. The United States, however, did not administer Hawaiian Kingdom law, but instead unilaterally annexed the Hawaiian Islands in 1898 during the Spanish-American War. Now, according to Professor Brownlee, after the defeat of Nazi Germany in the Second World War, the four major Allied powers assumed supreme power in Germany. The legal competence of the German state, its independence and sovereignty, did not, however, disappear. What occurred is akin to legal representation or agency of necessity. This is where these Allied powers served in the absence of the Nazi government that was overthrown, and it administered German law. Brownlee continues to state that the German state continued to exist, and indeed, the legal basis of the occupation depended on its existence. Now, annexation is a unilateral act, and it's also not lawful under international law, especially during a belligerent occupation. According to the Handbook of Humanitarian Law in Armed Conflicts, the international law of belligerent occupation must therefore be understood as meaning that the occupying power is not sovereign, but exercises provisional and temporary control over foreign territory. The legal situation of the territory can be altered only through a peace treaty. International law does not permit annexation of another state. Now, regarding Palestine, the Israeli Foreign Minister, Eban, stated, the existence of a state is a question of fact and not law. However, Judge Crawford from the International Court of Justice explains, a state is not a fact in the sense that a chair is a fact. It is a fact in the sense in which it may be said a treaty is a fact. That is a legal status attaching to a certain state of affairs by virtue of certain international rules or practices. In a civilian law, a state is a legal or juridical fact with legal consequences. So another way to explain this is, you have chairs in a room, okay? The existence of each of those chairs is a fact, but one of the chairs is a throne, and only a monarch can sit on that throne. So if someone sits on that throne who is not a monarch, there's a legal consequence for that, whether it's trespass, right, treason, or whatever the case may be. The point that I'm making is, of all the chairs that are facts, it is the throne that is considered a legal fact. And that's what Judge Crawford was making reference to. Under international law, the military overthrow of a country's government does not equate to an overthrow of a state. According to Judge Crawford, there is a presumption that the state continues to exist with its rights and obligations, despite a period in which there is no effective government. And belligerent occupation does not affect the continuity of the state, even when there exists no government claiming to represent the occupied state. And that's what Professor Brownlee was referring to with regard to the German state, when its government was overthrown, and also during that same time frame, the Japanese state, when the Japanese government was militarily overthrown. Now, according to Professor Matthew Craven from the University of London, if one were to speak about a presumption of continuity, one would suppose that an obligation would lie upon the party opposing that continuity to establish facts substantiating its rebuttal. The continuity of the Hawaiian Kingdom, in other words, may be refuted only by reference to a valid demonstration of legal title or sovereignty on the part of the United States, absent of which the presumption remains. Now, a valid demonstration of legal title is a treaty of cession. In our case, doesn't exist. So here's the United States of America, right? And how the United States acquired territorial sovereignty from other countries that expanded the territory of the United States. The first ceded lands under a treaty of cession was by the French, also called the Louisiana Purchase in 1803. Later in 1819, the Spanish ceded what was Spanish territory, which is now Florida. And the Pacific Northwest was ceded by the British in 1846. In 1867, the Russians ceded by territory Alaska. And all territory north of the Rio Grande, right, which we know today as California, New Mexico, Texas, Arizona, Utah, that was transferred by the Mexican government under the 1848 Treaty of Guadalupe Hidalgo, which was a peace treaty that ended the Mexican-American War. So the presumption of state continuity, or the continued existence of a state, is similar to the presumption of innocence. A person on trial does not have the burden to prove their innocence. Rather, the prosecutor has to prove beyond all reasonable doubt that the defendant is not innocent. Without proof of guilt, the person is innocent. That person does not have to take the stand to prove their innocence. That is how powerful the presumption of continuity means, because instead of looking for whether or not the kingdom exists, all you have to verify is that it did exist as an independent state, which would shift the burden on an opposing party, namely the United States, to show evidence that it extinguished the Hawaiian Kingdom. There's no such evidence because there is no such treaty. The Lorenzo principle, State of Hawaii versus Lorenzo. This State of Hawaii appellate case has become a precedent since 1994 that addresses whether or not the Hawaiian Kingdom exists. So in 1994, after the Congress passed a joint resolution apologizing for the United States' illegal overthrow, an appeal was heard by the State of Hawaii Intermediate Court of Appeals that centered on a claim that the Hawaiian Kingdom continues to exist. That case is State of Hawaii versus Lorenzo, whose decision came to be known as the Lorenzo Principle by the federal court in Hawaii. The State of Hawaii Supreme Court and the appellate court applied the Lorenzo Principle in 53 cases since 1994. And the federal court applied the Lorenzo Principle in 17 cases, 2 of which came before the Ninth Circuit Court of Appeals. Now, in the Lorenzo case, the appellate court stated that Lorenzo appeals, arguing that the lower court erred or committed an error in denying his pretrial motion to dismiss the indictment. It was a criminal indictment. The essence of the motion is that the Hawaiian Kingdom was recognized as an independent sovereign nation by the United States in numerous bilateral treaties. The kingdom was illegally overthrown in 1893 with the assistance of the United States. The kingdom still exists as a sovereign nation, and he is a citizen of the kingdom. Therefore, the defendant was arguing that the courts of the state of Hawaii have no jurisdiction over him. Well, the appellate court placed the burden of proof on Lorenzo as the defendant. In 2014, the Supreme Court clarified this burden in State of Hawaii versus Armitage. The Supreme Court stated, Lorenzo held that for jurisdictional purposes, should a defendant demonstrate a factual or legal basis that the Hawaiian Kingdom exists as a state and that he or she is a citizen of that sovereign state, a defendant may be able to argue that the courts of the state of Hawaii lack jurisdiction over him or her. While the Lorenzo Appellate Court affirmed the trial court's judgment and denied Lorenzo's appeal, it did admit that the court's rationale is open to question in light of international law. So what they're saying is, when they place the burden of proof on Lorenzo or the defendant, this may be open to question in light of international law. Well, as I presented earlier, international law provides for the presumption of innocence, meaning you don't try to prove the kingdom exists, actually try to prove that it doesn't exist, but that's not up to Lorenzo. That will be up to the party opposing the Hawaiian Kingdom's continuity. So by not applying international law, the court concluded that the trial court's decision was correct because Lorenzo presented no factual legal basis for concluding that the kingdom continues to exist as a state. Since 1994, the Lorenzo case became a precedent case in state of Hawaii and federal decisions. The latest decision in the state of Hawaii was last year. Clearly, the Lorenzo Appellate Court admitted that by placing the burden of proof on the defendant that the kingdom continues to exist as a state may be wrong in light of international law, which it was. Because international law provides for the presumption of state continuity, despite its government being overthrown, the burden in the Lorenzo case shifted to the prosecution. You don't prove the kingdom exists, but rather you prove that the kingdom does not exist. The Lorenzo principle transformed the international rule of presumption of state continuity into a rule of evidence, a starting point. The Lorenzo Appellate Court also admitted under international law that the illegal overthrow leaves open the question whether the present governance system should be recognized. That's the state of Hawaii. The Lorenzo principle transformed, there we go. The presumption is not the existence of the state of Hawaii and its courts, but rather the existence of the Hawaiian Kingdom as a state. So how do you right the wrong? How do you address this complicated and complex issue? Well, steps were taken to restore the Hawaiian government. Now, mind you, for the Hawaiian Kingdom to exist as an independent state is not because of restoring a government, but rather it is because of international law. But it would be the restoration of the Hawaiian government that would lead to the exposure and education of why the Hawaiian Kingdom as a state continues to exist. The effective control of Hawaiian territory by the United States and its proxies, the provisional government, the republic, the territory, the state of Hawaii, since January 17th, 1893, did not extinguish the legal status of the Hawaiian Kingdom as an independent state under international law. It was just forgotten. Judge Crawford states, pending a final settlement of the conflict, belligerent occupation does not affect the continuity of the occupied state. The governmental authorities may be driven into exile or silence, like the Hawaiian Kingdom was silenced, and the exercise of the powers of the state thereby affected, but it is settled that the states themselves continue to exist. According to Professor Marek, it is always the legal order of the state which constitutes the legal basis for the existence of its government, whether such government continues to function in its own country or goes into exile, but never the delegation of the occupying state or the occupier, nor any rule of international law other than the one safeguarding the continuity of an occupied state. So before a government can be restored, it has to rely on the international rule that safeguards the continuity of the occupied state. The relation between the legal order of the occupying state is not one of delegation, but of coexistence. Now, according to Professor Rim, the state continues to exist even in the factual absence of government, so long as the people entitled to reconstruct the government remain. And these would be Hawaiian subjects. On February 28, 1997, Hawaiian subjects exercised their right of internal self-determination and took the necessary steps to restore the Hawaiian Kingdom government as a regency under the doctrine of necessity and Hawaiian constitutional law. A regency serves in the absence of a monarch. It is not a monarch, and Hawaiian constitutional law provides for that. Now, according to Restatement 3rd, Foreign Relations Law of the United States, it says the duty to treat a qualified entity as a state also implies that so long as the entity continues to meet those qualifications, its statehood may not be derecognized. This is very important. It also states that where a new administration succeeds to power in accordance with the state's constitutional process, no issue of recognition or acceptance arises. Continued recognition is assumed. So the United States cannot derecognize the Hawaiian state after it recognized it in 19th century. And the Council of Regency did not require diplomatic recognition by the United States or any other foreign government because it was the successor to Queen Liliuokalani's administration under Hawaiian law. Now, to say that the Council of Regency is not the successor, you would have to show that it was not established under the Constitution and laws of the Hawaiian Kingdom, but rather outside of those laws, which is why the provisional government in 1893 could not be assumed to be the successor to the government, but rather the provisional government in 1893 required diplomatic recognition because it was not a successor under Hawaii's constitutional law. It was brought about by an attempt of revolution. So addressing over a century of occupation, the Hawaiian Council of Regency was formed similar to the formation of governments in exile during the Second World War. In particular, the Hawaiian Council of Regency was established in similar fashion to the Belgian Council of Regency after King Leopold was captured by the Nazis. As the Belgian Council of Regency was established under Article 82 of the Belgian Constitution of 1821, the Hawaiian Council of Regency was established under Article 33 of the Hawaiian Constitution of 1864. Now, for myself, who am going to be a part of this restoration of government, aside from my knowledge and awareness of Hawaii's history and law, there is also that nobility tie, because Hawaii is a constitutional monarchy. My maternal great-grandfather is William Keanu Sai, who was born in 1880. He was a direct descendant of kings of Hawaii, Liloa, Umealiloa, Alapainui, and Keaweopala. He was also a high chief and served as one of the pallbearers for Queen Liliuokalani in 1917. And that's him with the circle, is identifying the white circle. He also was one of 14 pallbearers of high-ranking chiefs of the kingdom. And he was one of those pallbearers for Prince Kuhio in 1922, and there he is. My paternal third great-grandmother is High Chiefess Lucy Pohaiali'i Koi'i. She was the genealogy chanter for King Kalakaua and Queen Liliuokalani's court. She accompanied the Queen when the 1892 legislature was adjourned, and she would visit Prince Kuhio at his Waikiki home with my paternal grandfather when he was a child. I also have military experience. I'm a former field artillery officer. I attended Field Artillery Officers Basic Course in 1987 and Officers Advanced Course as a captain in 1990 at Fort Sill, Oklahoma. I attended Air Ground Operations School in 1990 at Herbert Field, Florida, and battlefield exercises in Japan, Korea, and Fort Lewis, Washington. I first started to serve as an officer as a battery fire direction officer, Charlie Battery, 1st Battalion, 487 Field Artillery. I then served as company fire support officer for the 100th Battalion, 442nd Infantry, where field artillery people are attached to an infantry unit calling for fire, artillery, mortars, and air support. I then served as battalion fire support officer for the 100th Battalion, 442nd Infantry. And then my final command was commander, Charlie Battery, 1st Battalion, 487 Field Artillery. And I was honorably discharged in 1994 as a captain. Now, part of our military training, and people who are in the audience who are officers know that there's a lot of professional development and training officers go through. These are the highlights of military professionalism ingrained in every officer, no matter what branch. Honesty and integrity, because lies erode credibility and undermine confidence. Straightforwardness add frankness to honesty and integrity. Candor is the forthright offering of unrequested information when something is known to be wrong. Also known as, sir, with all due respect, let me explain this. Confidence, because no task is daunting. When I was in the Op 4, or the opposing force, was the Soviet Union, and they were a monolith. And respect for the rule of law. So in assessing the situation of governance here in Hawaii, we had to look at this, and we understood that the governmental infrastructure in 1893 was called the Hawaiian Kingdom, with 3 branches of government: the executive branch, headed by a monarch, constitutional monarch. When the overthrow occurred, the illegal overthrow, all that changed was the Queen and her cabinet in the executive branch. And everyone in government was forced to sign oaths of allegiance to this illegal regime, who were being protected by the US Marines. In 1894, that insurgency renamed itself to the Republic of Hawaii. Mind you, it's still the governmental infrastructure of the Hawaiian Kingdom. And then in 1900, the United States Congress passed a law establishing what is called the Territory of Hawaii. All it was a name change of the Republic of Hawaii. The governmental infrastructure is still the Hawaiian Kingdom's governmental infrastructure. The United States did not create it. And then in 1959, the United States passed a law by its Congress transforming the Territory of Hawaii into the state of Hawaii. All we have here are name changes. The governmental infrastructure is the same. So when the occupation comes to an end, all that needs to happen, governmental infrastructure stays the same, but it just goes back to the original name. So this is what we understood we were facing, but people didn't know what was going on. They did not have the proper education, but there was a reason why they did it, and I'll be covering that. Well, actually, I covered that last presentation called Denationalization in the Schools. So restoring the Hawaiian government. So state sovereignty since 1843 under international law exists, never ceased to exist. The government was restored in 1997 as an acting government. The acting government established a strategic plan, okay, which entails 3 phases. Phase 1, verification of the Hawaiian Kingdom as an independent state and subject of international law. This is crucial because there is no way we can move to the next phase until we can get some international body, reputable body, to verify, not recognize, but to verify the Hawaiian Kingdom still exists as a state. Once we get verification by this body, then we move to phase 2. Exposure of Hawaiian statehood within the framework of international law and the laws of occupation as it affects the realm of politics and economics at both the international and domestic levels. Phase 2 will focus on the truth and accountability. And phase 2, by exposing the truth, will make people very, very uncomfortable. Because if they're not feeling uncomfortable, then you might say, it's frivolous. I can tell you, it makes people get very uncomfortable. Now, phase 3, restoration of the Hawaiian Kingdom as an independent state and a subject of international law. This phase occurs when the occupation comes to an end. Okay, so that's the strategic plan that the Hawaiian Council of Regency had established in 1997. Lawfare. According to General Dunlap, lawfare as distinguished from warfare, is the strategy of using law as a substitute for traditional military means to achieve an operational objective. The Council of Regency seeks specific objectives to ensure compliance with the law of occupation under the Hague and Geneva Conventions. The Council of Regency will implement its strategic plan through lawfare under international humanitarian law. Well, phase one was completed. The Permanent Court of Arbitration in the Netherlands verifies the Hawaiian Kingdom continues to exist as a state. The Permanent Court of Arbitration is an intergovernmental organization that creates ad hoc tribunals to resolve international disputes. The Permanent Court of Arbitration has institutional jurisdiction for the following disputes between two states. So here we have from the case repository of the Permanent Court of Arbitration, Ecuador versus the United States of America. This was a dispute that erupted in 2011 regarding a treaty provision. But before they could create the tribunal to resolve this dispute, they had to verify that at least one or both of the parties were states. So in this case, they identify Ecuador as a state and the United States as a state. The Permanent Court of Arbitration can also establish tribunals to resolve a dispute between a state and an international organization. Here we have District Municipality of La Punta, Peru, versus United Nations Office for Project Services. Here they identify Peru as a state and the United Nations as an international organization. They can also here establish a tribunal to resolve a dispute between a state and a private party. In this case, Levitis versus Kyrgyz Republic. Okay. They identify Levitis, who was a national of the United States, as a private entity, and the Kyrgyz Republic, Kyrgyzstan, as a state. So this is going to be the means by which the court is going to be able to verify, the Permanent Court of Arbitration, verify the Hawaiian Kingdom continues to exist, because if it didn't exist as a state, they would not have been able to create an arbitral tribunal to resolve a dispute. Well, this case was Larsen versus the Hawaiian Kingdom. It was at the Permanent Court of Arbitration from 1999 to 2001. And here from the case repository of the Permanent Court of Arbitration, Larsen versus Hawaiian Kingdom, they identified Larsen as a private entity and the Hawaiian Kingdom as a state. Phase one completed. The proceedings were initiated on November 8, 1999, by the filing of a notice of arbitration by the attorney for Lance Larsen. Before the arbitral tribunal was formed on June 9, 2000, the Secretary General of the Permanent Court of Arbitration informed the Council of Regency that it acknowledged the continuity of the Hawaiian Kingdom as an independent state. And the Secretary General also acknowledged the Council of Regency as the government of the Hawaiian Kingdom. Under Article 49 of the 1907 PCA Convention, which is what established the Permanent Court of Arbitration, the PCA's Administrative Council publishes an annual report on the work of the court, the functioning of its administration services, and on its expenditure. Currently, you have 122 countries that signed the 1907 PCA Convention. So they are contracting states that maintain the court. In its annual report from 2000 to 2011, the Administrative Council stated that the Larsen versus Hawaiian Kingdom Arbitral Tribunal was established pursuant to Article 47 of the 1907 Convention. Those contracting states with the Hawaiian Kingdom in its treaties, such as Norway, Sweden, Russia, Germany, Japan, Great Britain, to include the United States, are members of the Administrative Council and co-publishers of the annual reports that acknowledge the continuity of the Hawaiian Kingdom as a state. None of them protested what the Secretary General had found, that the kingdom still exists. And here is from the annual report of 2011. You notice the Hawaiian Kingdom, Larsen versus Hawaiian Kingdom, was a 33rd arbitration case. And if you notice the footnote number 2, look at the bottom, it says pursuant to Article 47 of the 1907 Convention. Article 47 is the jurisdiction of the court within within the conditions laid in the regulations, be extended to disputes between non-contracting powers or non-contracting states or between contracting powers or states and non-contracting powers or states. So the Hawaiian Kingdom government was overthrown in 1893, so it was not able to sign this treaty in 1907. So it is considered a non-contracting power or non-contracting state. So phase 2 had been initiated at the Permanent Court of Arbitration when the tribunal was formed, and exposure is going to take place in the Netherlands, in The Hague, at the hearing room of the Permanent Court of Arbitration.
The dominion of the Hawaiian Kingdom. In a summary, from 1840, the Hawaiian Kingdom possessed a constitutional government with elected and appointed officials and a complete system of civil and criminal laws to govern Hawaiian territory. On April 8, 1842, King Kamehameha III in Privy Council commissions 3 envoys to secure international recognition of Hawaiian independence. And these individuals are Timoteo Ha'alilio, William Richards, and Sir George Simpson. On December 19, 1842, Hawaiian envoys secured United States President Tyler's recognition of Hawaiian independence. November 28, 1843, the British government and the French government formally enter into a declaration recognizing Hawaiian independence. In our pleadings, we refer to that as the 1843 Anglo-Franco Proclamation. From that point, Hawaii has had its statehood recognized as being independent. As such, it began to enter into these treaties: Austria-Hungary, Denmark, France, Germany, Great Britain, Italy, Japan, Netherlands, Russia, Spain, and the United States of America. International recognition is evidence that the Hawaiian Kingdom had diplomatic representatives as of 1893 from those countries, as far as consulates and embassies. Rather, what we find is that the United States has never expressed itself as an occupier. Who would? They will never admit to occupation. But yet, to admit to occupation is, in a sense, to admit to the continued existence of the Hawaiian Kingdom as an independent state, which is really the crux of the matter, which is actually what is holding up, you might say, this issue to be resolved. Thus, the legal order, thus the reestablishment of the government, thus the relationship between its nationals.
I mean, to be slightly unkind, but thus the issue in rem. The point is that if the Hawaiian Kingdom continues to exist, its existence is in rem. It's not in personam. The Hawaiian existence, the Hawaiian Kingdom doesn't exist solely in the opinion of Mr. Larsen.
Right. But that existence should not be dependent upon an occupier, because you basically put the occupier on an equal footing with the Hawaiian Kingdom in its own territory. So really what needs to be addressed is what came before the occupation, whether the statehood or whether the legality or illegality of the Hawaiian Kingdom, not the illegality or legality of the United States as an occupier. Should the tribunal find it has jurisdiction, we are prepared to submit an offer of proof. We felt that this tribunal would offer some clarity so that for the first time we have a third party to present these type of merits that can be scrutinized by international law, rather than taking it before a United States tribunal, which could not rule on it to the detriment of itself. So in that sense, there is really no other way to address this issue. And the opportunity did arise because it was Mr. Larsen who was adhering to Hawaiian Kingdom law. And if the United States was adhering to occupation, not whether they're illegal or illegal, but if they were adhering to the laws of occupation, we wouldn't be here right now.
Now, the American Journal of International Law, which is a reputable law journal, gave a synopsis of what happened at the Permanent Court of Arbitration. And here's what they wrote. At the center of the PCA proceedings was that the Hawaiian Kingdom continues to exist and that the Hawaiian Council of Regency, representing the Hawaiian Kingdom, is legally responsible under international law for the protection of Hawaiian subjects, including the claimant. In other words, the Hawaiian Kingdom was legally obligated to protect Larsen from the United States' unlawful imposition over him of its municipal laws through its political subdivision, the state of Hawaii. As a result of this responsibility, Larsen submitted the Hawaiian Council of Regency should be liable for any international law violations that the United States had committed against him. So you can go to the Permanent Court of Arbitration's website, and if you go to cases, you will find the Hawaiian Kingdom, Larsen versus Hawaiian Kingdom case. And there it is. And it identifies the Hawaiian Kingdom as a state. Now, on the last day of the hearing, we're called to a meeting by the Rwandan ambassador who was assigned to Brussels, Belgium. So the Council of Regency was contacted by the Rwandan ambassador, says he has important information to convey to us. If we could meet him in Brussels from the Netherlands. So we caught the train, about an hour train ride. And we arrived in Brussels and we had a meeting with the ambassador. He offered to the Council of Regency that Rwanda is prepared to report to the United Nations General Assembly the prolonged occupation of Hawaii. That prompted myself and my legal team to have a short meeting. And when I sat back down in front of the ambassador, I thanked him, but we couldn't accept this offer at this time. It was too premature. We're here in The Hague addressing and standing on this profound status of the Hawaiian Kingdom, and our people back home are clueless of what is going on. So the council could not accept the offer because it needed to address denationalization. Over 100 years of brainwashing in getting people to believe something that's not true. Well, when we got back to the Netherlands, to The Hague, we looked to how can we address denationalization? So we looked up in the Department of the Army Field Manual 27-10, the law of land warfare, which covers occupations. And it says remedy for violation of international law, war crimes. In the event of violation of the law of war, the injured party, the Hawaiian Kingdom, may legally resort to remedial action of the following types. This is what we're going to zero in on. Publication of the facts with the view to influencing public opinion against the offending belligerent. And we're going to do this by me entering the University of Hawaii to get my master's degree, entering it in 2001, to get my master's degree in political science, specializing in international relations, and to get my Ph.D., but also to encourage additional research by other academics and master's and doctoral students. This has led to a plethora of publications that range from peer review, law review, and books. So it's quite astonishing what we're able to accomplish by engaging this information at the academic level using analytical rigor, and research and theories in order to explain our unique situation, which is so different from any other situation in the world regarding how long this occupation has taken place. This education at the university also prompted school teachers when they sent delegates from the Hawaii State Teachers Union to the National Education National Conference at its assembly in Boston in 2017. And they managed to get votes to support and pass a resolution that says the NEA, the National Education Association, will publish an article that documents the illegal overthrow of the Hawaiian monarchy in 1893, the prolonged illegal occupation of the United States in the Hawaiian Kingdom, and the harmful effects that this occupation has had on the Hawaiian people and resources of the land. When these delegates got back to Hawaii, I was contacted to see if I could write those articles for them to be published by the NEA. The first article published was on April 2nd, 2018, titled The Illegal Overthrow of the Hawaiian Kingdom Government. You notice the overthrow of the government, not the Hawaiian Kingdom as a state. And this was followed by the second article, the US occupation of the Hawaiian Kingdom. And the final article, the impact of the US occupation on the Hawaiian people, where I address denationalization that took place in the schools. This exposure also prompted United Nations human rights expert to send a letter of correspondence to judges, members of the judiciary of the state of Hawaii. Dr. Alfred Desaias stated, as a professor of international law, the former secretary of the UN Human Rights Committee, and co-author of the book, the United Nations Human Rights Committee Case Law, 1977 and 2008, and currently serving as the UN independent expert on the promotion of a democratic and equitable international order, I have come to understand that the lawful political status of the Hawaiian Islands is that of a sovereign nation state in continuity, but a nation state that is under a strange form of occupation by the United States resulting from an illegal military occupation and a fraudulent annexation. As such, international laws, the Hague and Geneva Conventions, require that governance and legal matters within the occupied territory of the Hawaiian Islands must be administered by the application of the laws of the occupied state, in this case, the Hawaiian Kingdom, and not the domestic laws of the occupier, the United States. Well, when you violate the laws of occupation, the Hague and Geneva Conventions, you commit war crimes. War crimes include denationalization, pillaging, unlawful appropriation of property, depriving a protected person of a fair and regular trial, destruction of property, unlawful confinement of a protected person, removing protected persons from the country, and involuntary conscription into U.S. armed forces. This also prompted the National Lawyers Guild to get on board. And this is an organization, a 6,000 member legal organization of attorneys in the United States. On November 10, 2020, they sent a letter to Governor Ige. The National Lawyers Guild, the oldest and largest progressive bar association in the United States, with 70 chapters and more than 6,000 members, calls upon the state of Hawaii and its county governments as the proxy of the United States, which is in effective control of Hawaiian territory, to immediately comply with international humanitarian law while the United States continues its prolonged and illegal occupation of the Hawaiian Kingdom since 1893. Dr. Federico Lenzerini, a professor of international law from the University of Siena, Italy, authored a legal opinion affirming the lawful authority of the Council of Regency under international humanitarian law, and thereby the Royal Commission of Inquiry's investigative authority of war crimes and human rights violations. The National Lawyers Guild supports the actions taken by the Council of Regency and the Royal Commission of Inquiry in its efforts to ensure compliance with the international laws of occupation by the United States, the state of Hawaii, and its counties. As an organization committed to the mission that human rights and the rights of ecosystems are more sacred than property interests, the National Lawyers Guild is deeply concerned that international humanitarian law continues to be flagrantly violated with apparent impunity by the state of Hawaii and its county governments. This has led to the commission of war crimes and human rights violations of a colossal scale throughout the Hawaiian Islands. International criminal law recognizes that the civilian inhabitants of the Hawaiian Islands are protected persons who are afforded protection under international humanitarian law, and their rights are vested in international treaties, and that there are no statute of limitations for war crimes, as you must be aware. It also attracted the attention of an international body of lawyers, the International Association of Democratic Lawyers, where they passed a resolution where it says, calling upon the United States to immediately comply with international humanitarian law in its prolonged occupation of the Hawaiian Islands. The IEDL fully supports the National Lawyers Guild letter to State of Hawaii Governor David Ige, urging him to proclaim the transformation of the state of Hawaii and its counties into an occupying government pursuant to the Council of Regency's proclamation of July 3rd, 2019, in order to administer the laws of the Hawaiian Kingdom. This would include carrying into effect the Council of Regency's proclamation of 2014 that bring the laws of the Hawaiian Kingdom in the 19th century up to date. Well, the Hawaiian Evangelical Association also sent a letter to Governor Ige, and they stated, therefore, in accordance with the UCC resolution, whereby Association of Hawaiian Evangelical Churches will provide communications to local, national, and international leaders and organizations calling for the compliance with international humanitarian law and an end to the illegal occupation of the Hawaiian Islands, we support the National Lawyers Guild letter to Governor Ige, dated November 10, 2020. Now, on August 11, 2021, the Hawaiian Kingdom, by its Council of Regency, filed an amended complaint for the federal court to order the state of Hawaii to comply with international law and transform itself into an occupying power to administer the laws of the Hawaiian Kingdom. And this is the complaint that was filed. This case has gone on for over a year and a half. On October 6, 2021, an amicus brief was filed by the International Association of Democratic Lawyers, the National Lawyers Guild, and the Water Protectors Legal Collective. Now, I don't want to go over the details, but this basically addresses the court needs to transform itself into what is called an Article 2 occupation court to be in compliance with the law of occupation. So let me quickly go through these slides to get to the end because I want to get some time for questions. Now, on February 16 of this year, the International Association of Democratic Lawyers and the American Association of Jurists sent a joint letter to all members of the United Nations General Assembly in New York City and Geneva, drawing attention to the American occupation. Dear Ambassador, the International Association of Democratic Lawyers and the American Association of Jurists would like to bring to your attention the prolonged and illegal belligerent occupation of the Hawaiian Kingdom by the United States since January 17, 1893. Both the IADL and the AAJ, as non-governmental organizations, have special consultative status with the United Nations Economic and Social Council and are accredited to participate in the Human Rights Council sessions as observers in Geneva, Switzerland. Well, on February 26, the IADL and the AAJ registered with the United Nations Human Rights Council to deliver an oral statement on the human rights violations that are currently taking place as a result of the American occupation. Along with the registration, the IADL uploaded the copies of the Royal Commission of Inquiry book, the National Lawyers Guild resolution and letter to Governor Ige, the IADL resolution, and the IADL AAJ joint letter to the ambassadors, as well as the PCA case description of Larsen versus the Hawaiian Kingdom. Both the IADL and the AAJ asked that I deliver the oral statement scheduled for this past March 2022. Before I could do that, I had to be accredited. So I was accredited by the United Nations High Commissioner for Human Rights. And here is that oral statement.
Thank you, and I now give the floor to International Association for Democratic Lawyers.
The International Association of Democratic Lawyers and the American Association of Jurists call the attention of the Council to human rights violations in the Hawaiian Islands. My name is Dr. David Keanu Sai, and I am the Minister of Foreign Affairs ad interim for the Hawaiian Kingdom. I also served as lead agent for the Hawaiian Kingdom at the Permanent Court of Arbitration from 1999 to 2001, where the court acknowledged the continued existence of my country as a sovereign and independent state. The Hawaiian Kingdom was invaded by the United States on 16 January 1893, which began its century-long occupation to serve its military interests. Currently, there are 118 military sites throughout the islands, and the city of Honolulu serves as the headquarters for the Indo-Pacific Combatant Command. For the past century, the United States has and continues to commit the war crime of usurpation of sovereignty under customary international law by imposing its municipal laws over Hawaiian territory, which has denied Hawaiian subjects their right of internal self-determination by prohibiting them to freely access their own laws and administrative policies, which has led to the violations of their human rights, starting with the right to health, education, and to choose their political leadership. Now, in the federal case, Judge Kobayashi issued 4 orders that violated international law and the Lorenzo principle. On August 24th, the Hawaiian Kingdom filed a motion for Judge Kobayashi to reconsider her order and to schedule an evidentiary hearing to compel the federal defendants, the president, vice president, and others, to show evidence that the Hawaiian Kingdom was extinguished as a state according to the Lorenzo principle. If the federal defendants are so confident that the Hawaiian Kingdom does not continue to exist, they shouldn't hesitate to show the evidence. As Sir Walter Scott wrote in 1808, "Oh, what a tangled web we weave when first we practice to deceive." This quote means that when you act dishonestly, you are initiating problems where a domino structure of complications will eventually run out of control. The Council of Regency's responsibility and duty is to not let things run out of control. Closing statement, The Hawaiian Kingdom, its existence is a legal question and not a political question. That legal question is answered by applying international law to facts that provides for the presumption of a state's continued existence despite its government being militarily overthrown. In other words, the legal question was already answered by the Permanent Court of Arbitration in 1999 when it acknowledged the Hawaiian Kingdom continues to exist. For people, it is all about education. For the United States and the state of Hawaii, it is all about compliance to the international law of occupation. And let me pass it over to Cassie. I apologize, Cassie. Hopefully we can get 50 minutes at least in for questions.
Sure. No need to apologize. Mahalo, Dr. Sai, for another great presentation. Well, let's just get into the questions then. The first one I have is, can you share some benefits of a deoccupied Hawaii?
Sure. First off, cost of living, because a lot of the money coming out of people's pockets are supporting the United States bureaucracy, right? So taxes. And then you get double tax because you get taxed by the state of Hawaii, and they get triple tax because you're taxed by the counties, right? Under Hawaiian Kingdom law, there's just one tax because it's the Hawaiian Kingdom. There's no county governments, right? Or federal government. So that is one benefit, right? Will immediately drop the cost of living, okay? And that is when they begin to comply with the law of occupation, not that you have to wait until the occupation comes to an end, because they will begin to administer Hawaiian Kingdom law. Another benefit would be tied directly to the Jones Act, right? So the Jones Act is otherwise known as the Merchant Marine Act, okay? It protects American ship owners, right? So when foreign ships with goods in the Pacific, they pass Hawaii or they bypass Hawaii, offload their goods in the port of Los Angeles, and Matson or ships from Hawaii have to travel there, reload, and come back. And that's what adds additional costs to bring that back. Now, under Hawaiian law and treaties that it has with countries as well as relations with their successors, so like the Dutch, we would have a relationship with Indonesia. So goods coming from Indonesia would stop in Hawaii on their way to the port of Los Angeles to offload. That would also help alleviate that cost of living. Another example, a benefit for Aboriginal Hawaiians, healthcare at no cost. Queen's Hospital, under Hawaiian Kingdom law, free healthcare. Not free, but it is subsidized by the government, right? So Hawaiians don't have to worry, Aboriginal Hawaiians don't have to worry about health costs. Also land, they can get fee simple titles at 17 cents an acre. Others can get parcels or remedy their titles under Hawaiian law, which will provide more continuity and protection. Because right now, all titles are not protected because they're all based on American law. And that's what gets people uncomfortable when you start to expose this truth. You know?
Thank you, Dr. Sai. The next question is there a current active registry for living Hawaiian subjects / citizens with proven lineage? If not, can an individual citizen establish such an entity, which could later be a legitimate source for validation of a Hawaiian subject? And this person, just one more note, said they're aware of the OHA registry with such info that was determined. And I think just wanted a little bit more context. I won't read their whole comment.
Yeah, no, there's no need for a registry, right? So nationality is acquired through Hawaiian law, not that you have to register for it, okay? Or to try to prove that you have it. So if anybody is a direct descendant of a Hawaiian subject, who was a Hawaiian subject prior to the overthrow of the government, they are a Hawaiian subject today, irrespective of race, color, creed, even where they live anywhere in the world. So under international law of occupation, people cannot acquire the nationality of an occupied state by being born on the territory, because that would open it up for the occupier to flood the gates, which is what Germany tried to do in Poland by migrating Germans, okay? Or what Israel, some of the people in Israel, not Israel, but the populations are migrating into Palestinian territory so that they can claim that their children are Palestinian, and therefore downplay any move to self-determination, right? So you can only acquire citizenship under international law, the law of occupation, by being a direct descendant of a Hawaiian subject before the overthrow, right? Now, as far as identifying who are Hawaiian subjects for the political process, like registering voters, right? Which will take place when the occupation comes to an end. That is covered under Hawaiian law by the Board of Education. They provide the census reports. So they would be that one, that entity that would tally who are Hawaiian subjects, where they live, but also who are aliens and resident aliens and where they live. Okay, so that's a government operation. So that would be done by the Board of Education. It may have to take place just prior to the occupation coming to an end. I don't know the specifics of the timing of it, but that would be required to determine who are Hawaiian subjects and who can participate politically.
Got it. So I'm hearing you say, Dr. Sai, it's not a current thing, but something in the future that is probably going to be done. Got it.
Yeah, because it has to be done according to how Hawaiian law is and not how we want to do it. So when the reference came to OHA's registry, well, that is an American law process that is trying to identify natives, right? The census report does not strictly look to natives to find them, right? But OHA has that as part of a registry so that they can get benefits. But all these benefits of the Office of Hawaiian Affairs is not Hawaiian Kingdom law. That's American law.
Right.
Right. And that's where we have to separate that. And again, I want to keep reiterating, this is where things get a little uncomfortable.
Got it. Thank you. Next question. Dr. Williamson Chang argued using only laws of the USA that the Hawaiian Kingdom still continues to exist. Would you agree that the Hawaiian Kingdom will not achieve justice using the laws of the USA? Would you also agree that justice for the Hawaiian Kingdom will not be achieved using the principle of indigenous people from the United Nations?
Again, this is the complex issue. You're trying to untangle this web of lies, and what do you have left? So it's not taking a position of Hawaiian Kingdom, period, United States, period. Because of the law of occupation, there is an interplay that takes place. Now, what has been imposed here is illegal, but you cannot deny the fact that we're caught in it. So you cannot just deny it, but how do you unravel that? And that's why that federal lawsuit is important. But more importantly, why the Permanent Court of Arbitration's case was fundamental in the verification process, not the recognition. Now, within certain rules, those rules can be used under American law to achieve compliance. And that goes to that Lorenzo principle that I covered. So the courts have developed this standard of evidence that needs to be presented, right? So what happens then is defendants can use the Lorenzo principle correctly to show or put the burden on the opposing side, the prosecution, to prove that the kingdom doesn't exist, right? So this is the scientific approach that we use in academic research. You don't try to prove something when you do research. What you do is you try to falsify it. And if you can't falsify it, then it is a given. Not that it's true, it's a given, right? It's a fact that you cannot deny. That is profound as to how we've moved from then just pure ignorance, which me included, to where we are now. But it is through education and asking the right questions. So you can't use the federal court and the state courts to file a complaint under American jurisdiction. But you can file a complaint, as we did with the federal court, that we can seek justice, enforcement of rights, but this court is not correctly set up yet. You have to transform yourself into an Article 2 occupation court, which Judge Leslie Kobayashi is dealing with. And this case is going on for over a year and a half, right? Now, what would trigger her? What would compel Judge Kobayashi to transform into an Article 2 occupation court? That would be the Lorenzo principle. So if the federal defendants, the United States president, right, the vice president, and these other federal officials named in the complaint, if their representative, called the Department of Justice in Washington, D.C., who's part of this case, all they have to do is proved the kingdom does not exist, game over. Not that we have to prove the kingdom exists. No, it's a presumption. And the Permanent Court of Arbitration already verified it. So once the United States cannot provide any evidence, then that would trigger Judge Kobayashi, where she would be compelled to transform the court in Hawaii, federal court, into an Article II occupation court in order to administer the laws of the occupied state. So this is just an example of how complex things can be, but you gotta have a legal mind. You gotta understand history, especially with Hawaii, and precedents. Yeah, so my job is to try to make it much more simpler, which is why, and how I teach at the University of Hawaii, how can I break things down so that it's comprehensible and not so complex? But I do admit it is, yeah.
Yeah, if I have one takeaway, it's definitely that this is a complex situation. Okay, well, for our next question, to be honest, I don't fully understand, but let me read it and maybe you'll have a response. Tort laws on the restitution for our people's grave multi-generational trauma. Do you want to speak on that?
I would assume that they probably are referring to denationalization, right? So if you look at denationalization, it is a war crime, okay? It is. And it was established as a war crime in 1919, right? Now, denationalization, by definition, is to obliterate the national consciousness in the minds of children, not the minds of adults, children. So that's when occupiers like Germany and Italy take over the schools of the territories they're occupying and try to change the minds of the children into speaking German or speaking Italian or only learning German ways of governance, right? So clearly that was traumatic for my grandparents. So my grandparents, that generation was the first generation to have suffered, I would assume traumatically, of this national consciousness being wiped, right? Where you cannot speak the language of Hawaiian as a national language, you speak English as the national language of America, right? All you learn is American history, not Hawaii's history. That's why nobody knew this information. So by the time it got to my parents' generation, my dad didn't know anything. When he went to St. Louis, my dad was born in 1939, but when he went to St. Louis, he didn't know anything. That wasn't being taught. And by the time it got to myself at the Kamehameha schools, in high school from 1978 to 1982, I was clueless. I didn't know anything. I mean, in fact, I went to a military college, New Mexico Military Institute in Roswell, New Mexico, to get my commission as a second lieutenant in the Army. I didn't know. But I, for one, I can honestly say, I can only speak for myself. I cannot find any trauma in me with regard to denationalization. I'm a victim of denationalization, but I can't say that I suffered trauma as my grandmother did. Or even did she? Was she so young? She didn't know that it was traumatic, but rather just her mind just accepted it because that's the way it appeared to be, right? I don't know. And that's why research would have to be done on this at the academic side to try to find answers to this. But I can say, without the trauma, I, for one, am a victim of denationalization. So I am a war crime victim, right? Now, how I address that, well, it's what I do right now. So the one thing that I don't have is anger, right? As a former military officer, you don't get angry. You got to be calculated. You need to be open to new information that is coming so that you can adjust tactically, not strategically. Strategically, we got to bring compliance, right? Tactically, how do you achieve compliance? And that is one-on-one. That is when you're on the ground. And that's how things adjust. So I'm not angry at the United States. I'm not, right? It's just, this is not the United States. Deal with it. You know, like, sir, with all due respect, it's not the place you think it is. Let me explain why, right? So that's where candor comes in, but you also have to be respectful, right? But I also want to point out, this information is very different from the Native Hawaiian sovereignty movement, okay? Here we're talking about a country, And that Lorenzo principle, okay, used in the federal courts and the state courts, is referring to the Hawaiian Kingdom as a state from the 19th century. It is not referring to a new country, a native country through the sovereignty movement and nation building. Many people in the past have confused what we do with the sovereignty movement. Sovereignty movement is a political process where sovereignty is an aspiration. That's why they're moving toward sovereignty or independence. This is not about moving anything towards sovereignty, because sovereignty is in the country, not in the people. And that country, the state, continued to exist even when we didn't know that. So what international law did, it protected the country even though we didn't know anything. And then when we wake up, wow, it's still there. We just didn't know what it looked like. It's like walking past, trying to find a computer, but not knowing what it looked like. And then going, oh my God, it was on this table for over a century. That is kind of what you go through. And that's why education is key, so that people can make informed decisions. That's important. But if you're in government, if you deal with law, making decisions can have ramifications, criminal liability, war crimes. And that's why education is key.
Thank you, Dr. Sai. Let me wrap up with maybe one more question and then we'll be done for today. What happens when you notify the conference minister of the Hawaii Conference, UCC, that the Hawaiian Kingdom exists, and he publicly sends a letter out to Hawaii Conference churches denying the Hawaiian Kingdom's existence? Would the conference minister and the Hawaii Conference be in violation of international law?
I wouldn't go that far. I would just say that person doesn't know, because we should always give everyone the benefit of the doubt, because in the past I didn't know, and I may have said things that were not true, but I didn't know. What I recommend is, as far as education for that person, send that person or people of like mind the YouTube 4 videos of my presentation. You know, because again, it's a learning situation. It's not about hitting people on the head, right? It's about learning, but at the same time, a hammer may come down if certain elements are being fulfilled for the commission of a particular war crime. And I want to say, when I mention war crimes, people think shooting, right? No, war is shooting. Did you know it's legal to kill a soldier by a soldier? But it is a war crime for a soldier to kill a civilian, okay? But war crimes predominantly are not tied directly to violence. Under the 1949 Geneva Convention, war crimes include unfair trial, unlawful confinement, pillaging, destruction of property, right? So those are what war crimes are, not just killing, but also what kind of killings. So that's why in the case with Ukraine, the civilians getting massacred there by the Russians, those are war crimes, because those are not military targets. And that's what you see in the news. But that does not only include war crimes. War crimes are more expansive, and it's covered in the Geneva Convention. So I want to recommend that for this presentation that I gave, I want people to read the book Royal Commission of Inquiry, which is also on the site, right? And all the information is there regarding what I presented in these 4 presentations. I like to call it the one-stop shop of what's going on. And this is what it looks like. The Royal Commission of Inquiry book, and it's free. It's an ebook. And you also have authors there that have written their part. The renowned expert on international criminal law, Professor William Chavez from Middlesex University, London, very renowned. He speaks to the war crimes being committed in Hawaii. Now, do you think he would do that if this was frivolous? Because that would affect his reputation. Then we have Professor Federico Lanzarini from University of Siena in Italy on human rights violations. And then Professor Matthew Craven from the University of London on why the Hawaiian Kingdom continues to exist as a state. And then I have chapters in there on belligerent occupation of Hawaii and Hawaii's constitutional history. Also included in the book, treaties, all the treaties of the Hawaiian Kingdom, the Constitution, the proclamations from the regency, and also international humanitarian law, the Hague and Geneva Conventions. So that's why I like to call it the one-stop shop. So I encourage everyone to go and download that ebook and take the time to read it, especially after you've watched the presentations.
Mhm. Great. Well, mahalo, Dr. Sai, for sharing that resource with us, and mahalo nui for the 4 presentations that you've shared. They've just been excellent. Let me invite Linda to come back, and as I do, I would invite people to share their mana'o or their mahalo in the chat as well for Dr. Sai.
Mahalo.
Yes, I absolutely want to extend a huge mahalo to you, Dr. Sai, not only for your presentations these last 4 weeks, but for your dedication to research and applying that research in international law for the benefit of the Hawaiian Kingdom, and also for your commitment to education. One of the reasons that we're doing this series is that we do believe that there is a tremendous need for education, that there's so much information that so many people do not have, and there's so much complexity that many of us don't understand. We don't have the background or the information previously to understand it. So thank you for that so much, and also for extending grace to those who are still in the process of learning and who have not yet understood. That's why we're doing this, is so that people will have more information. Next week, we will start with Dr. Ronald Williams Jr., who will be talking about the church. He'll start off, the first session will be about the missionaries and about the original mission to Hawaii. In later sessions, he will be talking about the sons of the mission and the shaping of a new mission. He'll be talking about the church and what we have come to learn about the church during the time of the insurrection and also following that. And again, in that session, we'll also be looking at the past to inform us on ways forward. Thank you so much for being with us, and we hope to see you next week. Aloha.